Good morning, good morning. How's everybody this morning? Boy, I've got a nice snowy morning over here in the southeastern Washington, where I'm at. This morning, I'd like to talk to you guys about the Laughtenburg Act, and I'm going to do some reading on this particular piece of legislation. Good morning, Mr. Burrell. So, a lot of you might be subject to the Laughtenburg Act and have no idea that you are. And if you look into it, what the Laughtenburg Act and what the Laughtenburg Act does, well, you've got a situation here. It's absolutely terrible. All right. See if I can build up a little bit of an audience. I'll probably get right into this when I get about 3 in there. Hey, hello. Who's all with me this morning? I got 2 viewers. Say hi. All right. They didn't want to say hi. Nifty. Well, I guess I'm just going to get right into this. The 1968. They did this too, and this was interesting. They did this under the gun ban. Gun ban for individuals convicted of a misdemeanor crime of domestic violence. 18 U.S.C. 922 G9. Okay. The 1968 Gun Control Act and subsequent amendments codified at 18 U.S.C. 921 prohibit anyone convicted of a felony and anyone subject to a domestic violence protective order from possessing a firearm. The intended effect of this new legislation is to extend the firearms ban to anyone convicted of a misdemeanor crime of domestic violence. That was the intention. This bill passed with almost unanimous support and represents Congress's recognition that anyone who attempts or threatens violence against a loved one has demonstrated that he or she poses an acceptable risk and should be prohibited from possessing firearms. Congressional Record PS 11878, September 30th, 1996. This new provision affects law enforcement in 3 interrelated ways. First, it will assist in preventing those individuals who have demonstrated a propensity for domestic violence from obtaining a firearm. Second, it will assist law enforcement by providing a tool for the removal of firearms from certain explosive situations, thus decreasing the possibility of deadly violence. Finally, it will serve as a federal prosecution tool in certain situations where alternatives have failed. Qualifying offenses. As enacted, the statute defines misdemeanor crime or of domestic violence, MCDV, as any state or federal misdemeanor that, now get this, has an element, the use or attempted use of physical force or threatened the use of a bodily weapon committed by a current or former spouse, parent, guardian of the victim, by a person with whom the victim shares a child in common, by a person who is cohabitating with or has cohabitated with the victim as a spouse, parent, or guardian, or by a person similarly situated to a spouse, parent, guardian of the victim. This definition includes all misdemeanors that involve the use or attempted use of physical force. An example, simple assault, assault and battery. If the offense is committed by one of the defined parties, this is true whether or not the statute specifically defines the offense as a domestic violence misdemeanor For example, a person convicted of a misdemeanor assault against his or her spouse would be prohibited from receiving or possessing firearms. It is anticipated that this issue will be subject to litigation. In the event of such litigation, the terrorism and violence crime section should be notified so that assistance can be provided. Date of previous conviction. The prohibition applies to persons convicted of such misdemeanors at any time, even if the conviction occurred prior to the new law's effective date, September 30th, 1996. See attached State v. Brady, 26F, 3D, 282, Second Circuit. Okay. Denying the post ex facto challenge to the law, United States v. Walters. Post ex facto base challenge at 922G4 conviction. Limitations on previous convictions, 18 U.S.C. 921A 33B. To qualify, 1. At the time of previous conviction, the defendant must been represented by counsel or knowingly and intelligently waived the right to counsel. 2. If the offense of previous conviction entitled the person to a jury in that jurisdiction in which the case was tried. Either the case was tried by a jury or the person knowingly and intelligently waived the right to have the case tried by a jury, by guilty plea or otherwise. And 3, the conviction cannot have been expunged or set aside, or be an offense for which the person has been pardoned, had their civil rights restored. If the law of the applicable jurisdiction provides for the loss of civil rights under such an offense, unless the pardon, expungement, or restoration of rights expressly provides that the person may not ship, transport, possess, or receive firearms, the issue of restoration of civil rights must be carefully researched for each potential defendant. For example, in some states, a person automatically loses his or her civil rights upon the execution of a sentence of imprisonment, felony or misdemeanor, only to have the rights restored upon the defendant's release from prison or sentence. However, in those states, a person who does not serve a sentence of imprisonment may not lose their civil rights, and therefore this limitation may not be applicable. But in United States versus Indelicado, First Circuit Court, 1996, the court held that at least some of the instances, if one group of felons may possess a firearm because their rights were automatically taken away and then restored, then those who do not have their rights taken away may also possess a firearm. The terrorism and violent crime section can provide assistance in analyzing the particular cases. You guys still with me? All right. There is no law enforcement exception. One of the provisions of this new statute provided or removed the exemption that 18 U.S.C. 925 provided to police and military. Thus, as of the effective date, any member of the military or any police officer who has a qualifying misdemeanor conviction is no longer able to possess a firearm, even while on duty. We now have the anomalous situation that 18 U.S.C. 925A1 still exempts felony convictions for these two groups. Thus, if a police officer is convicted of murdering his or her spouse or has a protection order placed against him, they may, under federal law, still be able to possess a service revolver while on duty. Whereas, if they are convicted of a qualifying misdemeanor, they are prohibited from possessing any firearm or ammunition at any time. Currently pending before Congress are two bills that would substantially modify the impact of the amendment to this section. Prosecution considerations. In determining whether a particular case merits federal prosecution, you should consider the following factors: the date of the previous conviction, under what circumstances the firearm was obtained, whether there are indications of current or potential violence, i.e., recent incidences of domestic violence, would be a stronger argument for possession than if a number of years had passed since any domestic violence problems had occurred. Alternatives available to federal prosecution, state prosecutions, voluntary removal of a weapon, whether the potential defendant was on notice that his or her possession of a firearm was illegal, whether the potential defendant had made any false statements in obtaining the firearm. Even if the determination is made that prosecution is not warranted, steps should be taken to assure that the firearm is removed from the possession of the prohibited individual. Depending upon the situation, this might be done by having a local, state, federal law enforcement officer notify the individual of the application of the law and offer to take temporary custody of the firearm. In other, more volatile situations, it may be necessary to obtain a search and seizure warrant to assure that the firearm is removed immediately. The ATF has primary investigative responsibility over this section. However, in many locales, the ATF agents may not be immediately available. The department will be working with other federal agencies to determine what, if any, investigative alternatives are available. In the meantime, United States Attorney's offices should be working with the state and local law enforcement to establish guidelines for handling these cases, which often arise in emergency situations, such as when a local officer responds to a domestic violence complaint and learns that a firearm is present and one of the parties is prohibited under this statute. Okay, that's where we are with the Laughtenburg Act. This, ladies and gentlemen, is one illegal motherfucker. And I don't usually drop the F-bomb on my live videos, but this is about as illegal as a law can be. If anybody who stands there and tells you, oh no, they're not after your guns, honey. They don't care. You know what? They believe in the Second Amendment. They have never actually looked at the Laughtenburg Act. They state very clearly, you don't have to be convicted, although they make it appear that way, but it's not. You don't have to be convicted. You don't have to be tried. You don't have to be taken to court. All that needs to happen is a protection order. And now, you lose your rights to own, keep, possess, or transfer any firearm or any ammunition, which is now a felony for you to possess. See, I get the misdemeanor protection order, or it doesn't even have to be a conviction. I get my protection order against you. You're now ineligible for holding, keeping, possessing, transferring any gun or firearm, any ammunition of any kind. Step 2. Now I want to get you. Now I'm going to get you. So I'm going to tell that sheriff's deputy that you have one bullet in your trunk. One bullet. You forgot about it from your shooting, last weekend. It might be some small little .22. It makes no difference. Now, you can be prosecuted on a felony crime. Keep voting Democrat. Keep voting Democrat, people. Frank Laughtenburg. Democrats did this. This was democratically, by Democrats, this was a democratic mindset, because they couldn't overturn the Second Amendment. So they got this brainstormy, brainiac idea to get in your bedroom and initiate the Laughtenburg Act. And that's what they've done. And it's been challenged up until this summer, where 6 of the 9 the Supreme Court judges 6 of these motherfuckers said that this law is okay. Well, forgive me. A civil court does not have the ability to decide my guilt or innocence in any matter. They don't have the ability to do that. They are not geared to do that. So, one of two things I think should happen. A civil court should have their protection order ability restricted, and only a criminal court can issue this type of order with the benefit of a criminal conviction, or we have to do away with the whole damn thing. It's too easy to have an accusation, and I don't want to lose my rights because of an accusation. Alright. So I've touched on this. I'll give you guys a couple of minutes for some comments here. My timer is clicking. Let's hear what you guys have to say. Hey CJ, you're gonna have to come back. I'm taking questions now. You're gonna have to come back and watch this video. I just went over this Laughtenburg Act, and there's a lot of valuable information in there. So yeah. Family court will put gun restrictions on you and parenting plans. Now, forgive me for dropping the F-bomb, but there is no way this legislation should have ever even come close to Congress. And I don't know what it's going to take to overturn this. I certainly don't want to say, you know what, the only way to overturn this is to resort to violence, because that's just terrible. That's a terrible mindset to have. However, that's what you're left with. If you can't get our legislature to understand that this violates the law, then I don't know what can. I did not know that shall not be infringed didn't mean what it means. Yeah, I know. See, what they did was that they realized that they couldn't go after the Second Amendment, but they could go after you in your home. Okay, they couldn't abolish your Second Amendment, but they could say, well, any little argument that you might have with your spouse, and we don't think you should have guns, because we're just, that's just over the top, Mr. Bullshit. Bring me to a court and have me convicted of a crime. This is too broad form. And then this was enacted ex post facto, which means before the law, so if your conviction happened before this law went into place, there's no grandfather act. So it beckons one to wonder how many law enforcement and military personnel lost their jobs the very next day. Now, granted, this happened, the original ban was in 1968. The amendment was in 1996. So, I mean, they took this and ran with it. I don't know that, Mr. Burrow. I'll have to challenge that. I've yet to have one doctor say anything to me about being a gun owner. Mr. Klein says, that's the point of the Second Amendment, actually. Man, it's snowing. All right, so do you want to make you yeah, until you get a domestic violence no contact order, restraining order, anti-harassment order, till you get one of these orders filed against you, and then it'll be impossible. Especially if the spouse, the family member, the loved one, the live at the fucking roommate, they go in there and tell law enforcement where your guns are. This right here gives them explicit instruction that they should go and obtain a search warrant for your property. So where does this end? Where does this end? This entire piece of legislation should be overturned, crumbled up, and tossed in the garbage. On top of that, everybody who voted for this piece of legislation, and I don't give a fuck if I like them or not, they should be kicked out of office. Period. You voted for this, you're out. Never again will you sit and legislate and create law. That's my opinion. That's the Steve Ball thinking. Hang them all. All right. So I wanted to just get this shot off there. That is a basic, what I just read to you guys, and I got some comments here. A basic rundown of what the Laughtenburg Act is, what the Laughtenburg Act does. Thanks for joining me. You guys are awesome. Yes, it is a violation of due process, but I'm going to kill this video now. I've got 2 minutes left. I'm going to go ahead and kill this video, and we'll be talking to you guys very shortly.